welcome back. You're watching Your World at 10 now. On Friday, the Serious Frauds Investigation Office of the SFIO has asked former Satyam independent director Krishna Palepu to pay back 2.6 crore rupees that he was paid by the company as professional charges for a consulting assignment. The SFIO said Satyam did not take mandatory permission from the government to pay the Harvard professor, which is in violation of Section 309 of the Companies Act. That section refers to the remuneration of directors. Now, does this indicate that the SFIO is getting tough on Satyam's independent directors? Is this the only case against them, or are there more cases that they're likely to have to face? Joining us to answer that is SFIO counsel C. Raghu. Mr. Raghu, thank you very much for joining us on Your World at 10. Why is it that this issue of violation of Section 309 has come to light only 1.5 years after the fraud was discovered, and actually more than 2 years since the payment was made? Could this not have been discovered earlier, that a payment was being made to an independent director for a professional service that could actually violate the conflict clause and question his independence?
This was discovered only in the course of investigation by the SFIO, where questionnaires were addressed to the company, and the company, after disclosure of the records by the company, then we could find out.
Mr. Raghu, everybody knew based on the annual accounts of that year that Professor Palepu had been paid a fee for his professional consultancy job. This is over and above whatever he was being paid as an independent director on board. So why has it taken the government so many years to crack down on what could potentially be a violation?
It's like this. The balance sheets, they disclose that the payments have been made towards professional charges. They don't mention the name to whom it has been paid. The SFIO had addressed a letter to the company. When the company had replied in the year 2009, then we came to know that these amounts, which have been reflected in the balance sheet that they have been paid towards the professional charges, have been paid to Mr. Palepu, in fact. So that's the reason maybe there would have been a delay.
You've asked Mr. Palepu to refund the money. What is the response that you've got from his counsel? You've also included the other independent directors or other directors on board as part of this violation. What are you accusing them of, sir?
Because all the board of directors are responsible. In fact, only in this case, in this particular case, it's only Mr. Whole-time director, Mr. Ram Mainampati and Krishna G. Palepu, the directors. We are proceeding with, along with Mr. Jayaraman and Ramaraju and Ramlingaraju.
Okay.
The Ram Mainampati, being a whole-time director under Section 5, is also liable because he is in charge of the entire affairs of the company, the whole-time director. And insofar as the other director is concerned, he is the company secretary, Mr. Jayaraman. So he deals with the affairs of the company. So obviously he must be knowing. So we have made them as an accused, or the A1 to A6, and we said that the amounts have been paid to the accused number 6, that is Mr. Palepu, without the opinion of the central government as required under Section 309.
You have also filed cases against other directors in other matters. This is not relating to the Krishna Palepu matter. Can you take us through what those cases are and why you feel that some of the directors, especially independent directors on board, may be guilty of what you've accused them of?
In one case, in fact, we have made all the directors as accused. That is in relation to violation of Section 2172A, wherein the balance sheets do not disclose the particulars of all the employees, remuneration paid to all the employees.
Okay. So
this is a case wherein we have made all the directors as accused. In other cases, of course, we have made only Mr. Ramlingaraju, Ramaraju and the Ram Mainampati as accused, along with, in one case, with Vadlamun Srinivas. In only one case, we have made all these directors as an accused, because they have not furnished, and they are liable for that, because under Section 628, if a fact is suppressed, then all the directors would be liable. Any person who suppresses the fact is liable.
So you're accusing the company and its board of suppressing the actual record of employees, and therefore you have also filed cases against the independent directors on board. Do I understand that correctly?
Yes, exactly.
So is there any investigation currently going on against any of the independent directors on how is it that such a big scam, was not, in some sense, they were not cognizant of it, or they had no idea? And more importantly, the fact that they approved the transaction between Satyam and Metas, which was thereafter reversed. Are you doing any investigation, or is there any case on the anvil against independent directors for some sort of negligence on that count?
No, we have not filed any such case. We are not aware of that also. In fact, we have confined ourselves to the violation of the Companies Act, basically technical violation, that is the disclosure of the particulars in the balance sheets.
Okay.
Only to that extent we have filed these cases.
And have
maybe the CBI is dealing with those cases, with those allegations.
You also require Ramalinga Raju to appear in your cases. Now, the CBI seems to have run into a hurdle regarding Mr. Raju's claimed illness and therefore his inability to appear in court. How are you trying to deal with the fact that he may choose or he may not appear in court and therefore the cases may get delayed?
No, that's the reason we have requested the court to split the cases. Now, the cases have been split against Mr. Ramalinga Raju because it appears that there was a representation by his counsel that he is undergoing treatment in NIMS. So we asked the court to split the case, and now we are proceeding against other directors, Mr. Ramaraju and other directors in all the cases. And we have already led in the chief examination in 2 cases against the accused.
Have you received any communication from Mr. Palepu's counsel on what his response is to this case filed against him and the direction to refund the money?
No, we have not received anything, and it's a sub judice matter. In fact, they would answer in the court. They would not communicate with the...
Was he present in court?
Either my SFIO or
Was
counsel.
he present in court?
It's a case. It's a criminal case, so they'll build up defense maybe in the course of the trial.
Was he present in court, sir, when you filed these charges?
No, he's appearing through a special wakalat holder.
Special wakalat holder.
That CRPC enables him to appear through because it's a summons case.
Right.
Basically. So the court has allowed him to appear through a special wakalat holder.
How do you hope to overcome this issue of Mr. Raju's illness? Are you also making a request possibly of a trial held by video?
Once we complete the trial against other directors, then we'll take appropriate steps, file appropriate applications and see that by video conferencing or in some manner that his presence may be recorded. In his presence, the trial would be conducted.
So explain to me why are the SFIO cases separate from what the CBI has filed as, I think, 3 charge sheets as of now? How come both agencies are dealing with this separately, so to speak?
The CBI is dealing with the common law offences cases, wherein there is a fabrication, 468 forgery, fabrication of accounts and all this. These are common law offences basically. Okay. And we have confined our complaints only in respect of the violations of the Companies Act. These are technical violations, and these are all non-cognizable offences. Court would take cognizance based on a complaint filed by either the authorized person by the central government or the registrar of the companies. So would any shareholder, in fact.
So would you all also be in charge of the cases regarding the inaccurate accounting that was presented over the past many years at Satyam? Because that would also be a violation of the Companies Act, besides being a violation of many other aspects.
Because we are confining ourselves to the complaints where we have made allegations in relation to the account for 2005 to 2008.
Okay.
And because during the relevant period, the accused were the directors at that point of time. Regarding the other allegations, maybe CBI would be...
But the SFIO is not investigating the fabrication of accounts or the inaccurate representation of accounts and the fraudulent activity that took place. That is not part of the SFIO investigation, even though actually the SFIO is best placed to be able to conduct such an investigation, right?
No, so far investigation is concerned, so these complaints which we have filed, for the Special Economic Offences Court is concerned, we have confined only to the aspect of violation of the Companies Act, not more than that.
But would it not be a violation of the Companies Act if accounts were misrepresented or wrongly represented?
It is a violation. In one of the cases, in fact, we are alleging that that there was suppression of projection of wrong accounts, wrong figures. That's one of our alleged distorted figures. That's also a violation of Section 211 of the Companies Act. We have, in one of our complaints, we have alleged that.
This is the complaint regarding the payment of dividend to foreign shareholders, is it?
That's a different complaint. In fact, in complaint which filed against Mr. Ramalinga Raju, Ramaraju and Vadlamun Srinivas, we have specifically alleged that the balance sheets, they have shown distorted figures in the balance sheets, which which is in violation of Section 211 of the Companies Act.
So you have filed that complaint under the aegis of the SFIO. So that is part of the proceedings that you're undertaking in the Special Economic Offences Court.
Yeah.
Sir, can you give us a sense of, I know it's impossible to tell what the timeline of something like this will be, but it's been over a year since this fraud came to light. And, it's only now I understand that many of these complaints are being filed in court. Give us a sense of how long this will take to achieve some sort of resolution at this level of the court. Thereafter, I'm sure there are many other forums of appeal before it gets to the Supreme Court.
Insofar the complaints before Special Economic Offences Court are concerned, we are concerned, we will try to complete the trial as expeditiously as possible, maybe 1.5 years.
And thereafter, this can get appealed in the High Court, or does it get... No, but thereafter this gets appealed. If it is to be appealed, it gets appealed in the High Court?
It would be appealed in the High Court.
And thereafter there is the Supreme Court. So we're at least looking at another decade of investigations and charges.
These are all basically minor offences where some of these sections contemplate imprisonment, some they don't. They only contemplate imposition of fine.
Okay. So have you asked for a penalty or a fine to be paid by Krishna Palepu, or have you only asked for the refund of the money that he was paid?
Our prayer is for refund of the amount to the company. And also the fine to be imposed on all the directors who are responsible for this. And
the fine, what is the maximum limit for that fine, sir?
That is 5,000 rupees.
5,000 rupees?
5,000, yeah.
And what is the fine or the punishment possible under the charge of misrepresenting their accounts or financial accounts?
The maximum what the Companies Act contemplates is 2 years only. That's under Section 628 of the Companies Act.
2 years of imprisonment.
The section corresponding... Hello?
Yes, sir. 2 years of imprisonment. Is that correct?
Maximum. And with respect to sections, in fact, they themselves contemplate about 6 months imprisonment. Wherever particular section does not provide, the residuary section is that Section 628, wherein maximum 2 years imprisonment is there.
So, hypothetically speaking, if you do win your case, and if Ramalinga Raju, and especially since most of these cases are also filed against Ramalinga Raju, and if you do win the case and he chooses not to appeal, considering that he's already been in jail for over a year and a half, there's a good chance that he may not have to serve any further time in prison. Is that correct?
And that's
very hypothetically speaking.
Yeah, that's obvious. But the point is, whether we have proved the case or not, that would be the point.
No, I understand. I'm saying...
Because already is in jail and already is undergoing.
I'm looking at the positive scenario, saying if you do prove the case and if you do win and he chooses not to appeal, considering the fact that he's already spent over a year and a half in jail, he may actually have very little prison time to serve, even if you do win the case.
That's true. Because all the punishment, because he's been produced, a remand warrant would be issued to him. And the court has taken note of the fact that he's already in jail.
All right, Mr. Raghu, thank you very much for all the information that you provided us and for bringing us up to date with the investigations and the proceedings at the Special Economic Offences Court. This is in Hyderabad, and that was SFIO counsel, that's the Serious Fraud Investigation Office counsel, C. Raghu. And